The Western Cape High Court delivering a judgment on whether alleged Parliament arsonist Zandile Mafe is fit to stand trial. Let's listen in.
Fort England Hospital. My registrar says I said hotel, it's a hospital. And that period was to expire on the 24th of May. The panel that I appointed, being Drs. Shishoka and Puzi and Mr. Vazi, the clinical psychologist, had to report on two questions. Firstly, the capacity of Mr. Mafe to follow the court proceedings. And the second question as to his capacity to appreciate the wrongfulness of an act and act in accordance with that appreciation. They requested an extension of the period of observation, and today is the final date of that extension that I granted. I've indicated on the previous appearance, in the absence of Mr. Mafe, that there was a possibility that the matter might appear at an earlier date if the period or if the assessment is done prior to today's date. I was furnished with an electronic copy of the report on the 24th of May of this year. And it was sent from the Fort England Hospital under the letterhead of the Eastern Cape Department of Health. I caused a copy of the report to be sent to the parties, and asked for their view as to the further conduct of the matter. In light of the findings in the report. Mr. Mpofu, on behalf of Mr. Mafe, could clearly not consult with Mr. Mafe as he was in the Eastern Cape. And he attempted to consult yesterday, and I'm sure he'll place it on record fully. The Criminal Procedure Act has certain processes prescribed in matters where the particular chapter is applicable. It is for that reason that I asked certain questions of the legal representatives after receipt of the report. There was also a concern that the report might not have enough detail In the past, the reports were quite substantial with all the analysis and the observations and treatment the patient would have received. However, on inquiry, I was told that this is the way the reports are done now. And I satisfied myself that there are quite a few judgments of the courts that accepted reports in this fashion. When I realized by yesterday afternoon that I didn't have feedback from the defense, although the state had indicated their stance on the report, I then requested counsel to see me in chambers before the court this morning so that we could work through the logistical issues. And I'm aware that Mr. Mpofu could not get instructions yet from his client. It was for that reason that he most probably asked for the indulgence to approach the dock and speak to Mr. Mafe. I'm now going to request the parties to put their stance on the record and whatever else they wish to place on record. And I'm going to start with Mr. Mpofu for the defense. As I'm aware that Mr. Manigo is ready. Yes, Mr. Mpofu.
As court pleases, my lord. Firstly, just to confirm the blow-by-blow account that your lordship has given of the recent events since we were last here, but also just to appreciate or express our appreciation for the court's indulgence, in particular in respect of the logistical problems associated with the whereabouts of the accused and our ability to consult. Your lordship is quite correct. I arrived yesterday with the specific intention of consulting so that to make today easier, but there were other logistical issues which my attorney encountered with the prison authorities. Be that as it may, our intention would have been to consult with the client this morning, but of course I think it was more important to have the meeting with your lordship, which has really made things much easier, and we will therefore be consulting afterwards with him downstairs. Now, so we are indebted to the court in that regard. In respect of the report, we also confirm that we received it as it was sent by the court, and we therefore have to fashion our own attitude as the state has to it, and some of the consultations we'll be having today will involve that. And between now and the next date, which will come to the question of the next date, but between now and then we will then be able to either have communicated with the court in any event in between to communicate that attitude. As without getting into details, your lordship knows that depending on what attitude the accused takes, then it will determine whether we go this way or that way. So we are in touch with our learned friend, and we will also be in touch with the medical team insofar as it is necessary. That was also a matter that was cleared with your lordship in chambers, because after all, at this stage, they are your witnesses, my lord. So we're quite happy with the developments, and the parties have agreed a date, but I'll leave that to your lordship. Let me just check. Thank you, my lord. That will be all.
Just to add on to the comment of the medical team, as they are the court's witnesses, I had consented that the parties may consult with the medical team in whichever way they can arrange it between Mr. Monigo and the defense team. It seems they have been collaborating on that in any event, but they were hesitant, and this is more for the public to know that this wasn't done before because they couldn't consult with the court's witness or witnesses without my consent, which I have given to them in chambers as part of the discussion we've had this morning.
As God pleases. Maybe the only thing I might add then, my lord, is in the remaining time, obviously, it may or may not involve us having to rope in other professionals, but all that will depend on the consultations going forward. As God pleases.
Thank you.
My Lord, I concur with the court's summation of events prior to this appearance. I do confirm that a report has been received by the state, and the findings taken as per provisions of section 77.3 have been a unanimous finding with respect to the 3 medical professionals. And then with respect to the state's attitude towards the report, as the court has inquired regarding that, the state issues based on the report that the state is not disputing any of the findings contained in that report. Obviously, the state then will obviously further submit that section 77 is a defined application, and that is the point at which we are now. The defense needs to indicate whether they are indeed going to dispute or consent to the findings. And I think that is the state they are at. They have indicated they will be time to consult on this important aspect of the deadline, and the state has no objection to being granted that opportunity to get the interest of justice.
Yes, thank you, Mr. Monigo. The position is, if the parties are in agreement with the findings and the recommendations, the court will just follow the recommendations. If it is disputed, there is another process to be followed, and we will only know as time goes on whether we will get there. Now the last question that I have to the parties. You've seen the report. The report is now handed in court, so it becomes a court document. And there will be a lot of speculation in the public domain. The report deals with the medical condition of the accused. However, it's part of the court record, and the question is that I just want to hear the parties on what their views are on the media having access to the report, or should I bar the media from limited access, or should I just give the finding and make that public in the public domain? Or if you have any other views. I didn't discuss it with you in detail this morning, but it just struck me that there might be a request for access, and then I haven't given you an opportunity to address me. Mr. Mpofu, before you answer, there might be a way of dealing with it, is to not disclose the diagnosis, but rather the finding under the heading with section 79(4)(c).
The reference to the section.
Yeah.
As a publicist, my instructions are that, in line with what we discussed in chambers, and I don't think I think there's consensus between the parties that given the nature of the matter, it might be prudent not to disclose anything at this stage, particularly in view of, as I said, the nature of the matter, but also because one of the rights we have reserved is to have other experts. So it might well be that at a point where it's disclosed, then the complete picture will then be given. So we would, subject to what my learned friend have to say, maintain the position that I think we had all agreed on in
because you're still considering whether you can dispute the findings.
Dispute or bring in other experts. as court
After the
pleases. If you dispute,
consultation.
obviously. If you don't dispute, then, as you correctly summed up, then it follows a particular route. As court pleases.
Mr. Manigo?
Lord, considering at what point we are in these proceedings, I would have to confer with the counsel for the defense. Obviously, they still have to reserve their right whether they're going to be disputing either the finding or the diagnosis. My submission would be the proper time probably to disclose the report is if, in fact, we take this to the court or if there's consent by the defense.
Of course, if people have access to the amended section, the post-2017 section on what we've said, they will know what the findings are.
Absolutely. That's a good question.
They will be able to immediately understand when I spoke about the process and so forth and the consent. But, yeah.
I suppose just putting out the diagnosis there while the defense hasn't indicated whether they're disputing it or not may be problematic as we go forward. But I think as soon as there's clarity on the attitude, then the report is obviously.
It might also, in the event that I rule that I'm not going to disclose the report, that's the court's report at this stage, and in the event that the parties come to an agreement before the next appearance, that I can then say, well, you can have access to the court file.
Yes.
It's in the court file. There has been agreement now. Anybody that wants to can have access to the court file.
Yes.
Yes, Mr. Mpofu.
Thank you, my Lord. Mine is merely to say I'm indebted to the attitude displayed by my learned friend and also the qualifications put by the court. We are in agreement that the course agreed on is in the interest of justice at this stage, as the court pleases.
Thank you. We've agreed on a date in chambers. So I'm ready to give a ruling on the disclosure or not. I'm going to order that the contents of the report, which is styled a psychiatric report, not be disclosed at this stage.
As please.
For the following reasons. The Act provides that a party may dispute the findings in these type of reports. And in the instant matter, the defense had not had an opportunity to consult with their client about it. Whether they want to dispute it or not. It goes to his medical condition, and I will therefore give them that opportunity to consult. In the event that an agreement is reached on the findings before the next date, I shall issue an order that the full contents of the court file can be disclosed. It doesn't mean that legal scholars and or lawyers will not be able to immediately speculate as to what the findings are, because a clear reading of the Act will give them a good idea. That's up to people that want to interpret. I have raised with counsel in chambers this morning a further aspect. That in light of the prima facie findings presented to me, I am going to order that the accused, Mr. Mafe, be detained in the hospital section of the prison. And I will endorse his warrant of detention to that effect. To give sufficient time for the consultations to take place, a decision to be made on the way forward, and the potential second stage of Section 77, where evidence might be led I've determined, in consultation with the legal representatives for the state and the defense, that we will need approximately a month for all the planning and consultations to take place. We've therefore determined that the date of the 13th of July would be appropriate. It is a date that falls within the court's recess. But I've indicated I will come in and deal with the matter. I will also, over and above the endorsement of the warrant of detention, attach the contact details of the medical team of Fort England to the warrant for correctional services to consult with them if they so wish. And that would be in relation to the potential medical assistance to be granted to Mr. Mafe whilst incarcerated. Mr. Mafe, do you understand that? So the matter is then postponed till the 13th of July of this year to be heard in this court. The accused to be held in custody at Paulsmoor in the hospital section. Warrant officer, we will prepare the warrants in my chambers and then we can just collect it from Mrs. Davids. Thank you.
Escort, please.
Court adjourned.
And the court has adjourned in Zandile Mafe's fitness to stand trial. The judge ordering the contents of the psychiatric report to not be disclosed at the stage. He gave a couple of reasons for this judgment and decision, saying, number one, the Act provides that a party may dispute a finding within these reports. Defence, of course, had no opportunity so far to consult with their client on whether they actually wanted to dispute the findings or not. So it has more to do with his medical condition, and therefore he will be granted that opportunity to consult with his lawyers and decide whether or not to dispute the findings. But in the event that a decision is reached on the findings before the next day, the judge did mention this, that he'll issue an order that the full contents of that report and that file can therefore be published. But it doesn't mean that in the interim scholars cannot speculate. So it's up to those who actually want to speculate according to the Act and to further interrogate. But he's also raised this issue with counsellors within chambers just in light of the prima facie order. But so the judge has decided that he will, of course, order Mr. Mafe, Zandile Mafe in this regard, to be detained in the hospital section of the Paulsmoor prison in the interim, and will endorse that warrant of detention to that effect, that he is, of course, held in the hospital section. So this will therefore give sufficient time for consultation as well as a way forward to be paved. And the judge mentioning it will need approximately a month. So therefore deciding that the 13th of July would be the next date of postponement to have, of course, Zandile Mafe appear once again in court. So that adjourns court in that matter. And I suppose we'll be heading back to court once again with Zandile Mafe's case on the 13th of July. In the interim, though, he'll continue to be held at Paulsmoor, but in the hospital section.